All rise. Superior Court of Clark County is now in session. Honorable Mary Staley Clark presiding. Please be seated and turn off cell phones off.
Good afternoon, everyone. I've already, press had some inquiries about whether they needed Rule 22s again, and I didn't see any reason for that, so we can dispatch with that. Prior objections can be noted for the record. Will that be sufficient for the defense?
Yes, ma'am.
Very good. We are here to conduct the sentencing in the case of the State of Georgia versus Justin Ross Harris. Brian, do you have a copy of the Bill of Indictment? Thank you. This is General Bill of Indictment, State of Georgia versus Justin Ross Harris, General Bill of Indictment number 143124. The case was tried during the months of September, October, and November in Glenn County, Brunswick, Georgia, where the case had been moved and the venue changed for purposes of finding a jury. In March of this year, 3 weeks were spent trying to find a qualified jury in Cobb County, pool of jurors in Cobb County. That was not able to be accomplished, although the effort to do so was a strong effort. There's nothing else to be said, but it was a very strong effort. It did not occur, and the case was transferred to Brunswick, to the Brunswick Judicial Circuit, Glenn County. First, I want to say that, and I want to thank the Brunswick Judicial Circuit for their help and hospitality during the trial of the case of the State of Georgia versus Justin Ross Harris. And I particularly want to thank the judges of the Brunswick Judicial Circuit for allowing us to come and showing extraordinary support and help and extremely high levels of professionalism. I particularly want to recognize Chief Judge E.M. Wilkes and Judges Stephen Scarlett, Stephen Kelly, Roger Lane, and Anthony Harrison and their excellent support staff. I also want to thank Glenn County Sheriff Neil Jump and the deputies assigned to our trial in Brunswick, and the bailiffs as well. And I need to recognize Cobb County Sheriff Neil Warren and Colonel Robert Willard and Lieutenant Keith Raines, who provided our security detail in Brunswick. I also need to recognize some of our Cobb County Court Administration folks who made all the difference, particularly during jury selection. Court Administrator Tom Sharon and Bill Pardue and Bob Pierce. And David Tyler with Cobb TV 23, who worked with the press and made that interface seamless. I want to recognize the excellent legal representation both sides of this case received, the State of Georgia and the defendant, Justin Ross Harris. I want to recognize from the District Attorney Vic Reynolds' office, Chuck Boring, Jesse Evans, and Susan Treadaway. And I want to recognize for the defense, Maddox Kilgore, Brian Lumpkin, and Carlos Rodriguez. Ladies and gentlemen, it was a professional pleasure to work with you under trying circumstances exacerbated by 2 hurricanes. Now, before we take evidence and argument, I want to clarify for the defendant and the public the sentencing parameters based on this Bill of Indictment. I want to turn our attention to count 1 of the Bill of Indictment. That will be the count of malice murder, to which the jury has found the defendant guilty. Mr. Boring, what do you contend are the sentencing parameters?
Judge, I believe for that count, the parameters are either life with the possibility of parole or life without the possibility of parole.
Does the defense agree or disagree?
We agree.
Count 2.
Your Honor, I believe count 2 as a matter of law is vacated by law, so there would be no sentence for count 2.
And do you agree or disagree with that?
We agree.
Count 3.
Your Honor, count 3 as well would be vacated as a matter of law, so there would be no sentence for that count.
Does the defense agree or disagree?
We agree.
Count 4,
Your Honor, that's a possible sentence of 5 to 20 years in prison, and I believe that can run either concurrent or consecutive to count 1.
agree or disagree?
We would argue it merges as a matter of fact.
We're going to have to take an argument on that. As to count 5,
Your Honor, I believe count 5 would merge into count 4, so there would be no sentence for count 5.
all right. Count 6,
Count 6,
Your Honor, if that's a criminal attempt of a criminal statute, it would be 1 to 10 years in prison on count 6.
with the possibility of parole.
Yes, Your Honor, and that can either run concurrent or consecutive to counts 1 and 4.
Do you agree or disagree?
we agree.
Count 7 and 8 are both misdemeanors.
That's correct, Judge, and again, those would be with the possibility of parole and could run either concurrent or consecutive to the other counts.
Of course, the defendant has already served that.
Yes, Your Honor.
Okay. All right, let's take the argument then on merger as to count 4. I think it would be in the nature of argument, the defense should start.
We have no argument. It's just simply our position, it merges as a matter of fact.
What says the state?
Your Honor, I would cite to Lupo versus the state, LUPOE. That is a November 21st, 2016 decision by the Georgia Supreme Court discussing merger in cases where the underlying felony, in this case 2 and 3, are vacated as a matter of law. When those counts are vacated, the underlying felonies then do not necessarily merge. In this case, it was armed robbery, aggravated assault, and other acts or other crimes charged that did not merge as a matter of law into malice murder. Both crimes had different elements. Your Honor, also cite to Noel versus the state, which is 297, Georgia 698, 2015 Georgia Supreme Court decision. That actually involves a case involving felony murder conviction where other felony murders were vacated as a matter of law. One of the underlying felonies for the felony murder was a cruelty to children in the first degree. This was a child homicide. The Supreme Court held in that case that the cruelty to children in the first degree did not merge as the felony that was charged as a homicide based on that cruelty was vacated. Thus, the Supreme Court actually said it needed to be sent back for resentencing because there should have been a sentence exacted on the cruelty to children. That's exactly what we have here.
Any further argument of the defense?
No, ma'am.
I find that because of the convictions in counts 2 and 3 being vacated as a matter of law, in count 4 there is no merger, and therefore the sentencing parameters are 5 to 20 years. And I note the defendant's exception to the court's ruling. All right. I believe we're at a point where we can begin to take evidence in aggravation and mitigation. Does the state have anything to say before we do that?
We have no further evidence than what was put out of trial, Judge.
And for the defense?
No evidence.
All right. Then we have argument. We can proceed with argument. I'm ready to hear what you all have to say.
Your Honor, we would waive any other ruling.
For the defense,
We have no argument.
you need to be standing up when you speak to me.
We have no argument.
Thank you. And your argument.
Just for appellate purposes, I think we all understand why the defense would be doing that, but just as a matter of record, we've asked them to put on the record, this is a matter of trial strategy. They've discussed it with Mr. Harris, and they're making the trial strategy decision not to present any mitigation evidence at this time.
Mr. Kilgore.
I don't have to do that, and choose not to.
Well, I'll put it on the record, and I'll speak to Mr. Harris directly. Mr. Harris, you have a right at this time to offer evidence in mitigation. You can call witnesses. They can be put up for the purposes of testimony. The nature of mitigating evidence is mitigating or extenuating facts or circumstances are those that do not constitute a justification or excuse for the offense, but that in fairness and mercy may be considered as extenuating or reducing the degree of moral culpability or blame. Evidence such as that is generally along the lines of lack of a prior conviction, youth of an offender, circumstances such as perhaps drug addiction or something along those lines. And every defendant is entitled to have that presented in a sentencing hearing before a court considers an appropriate sentence if they wish. They can put up evidence. If there is no evidence, the evidence of the trial can be considered, just as for the state in the nature of aggravating evidence. And whether to do so or not is a defendant's choice after consultation with counsel. So I want to make sure that you heard what I just said to you. Did you hear what I said?
Yes, ma'am.
Have you consulted with your attorneys about this?
Yes, ma'am.
Right. If you have any disagreement with the way it's being conducted, now is the time to speak. All right. All right. Is there anything else the state has concerns of?
No, Judge, I believe that handles that.
I'd like to proceed.
Yeah, Judge, there's not much to argue or say in this case. I think the evidence that was presented at trial and the jury's verdict basically says it all. The evidence showed that this defendant was driven by selfishness and committed an unspeakable act against his own flesh and blood in this case. Because of his behavior, a 22-month-old child was killed. A child's death in the most torturous, horrific, unimaginable way possible. Because of that, Judge, and because there is absolutely no mitigation in this case, there is no justification. This is basically the most aggravated type of killing of another individual, specifically a young child. And I think that based upon the evidence that came out and the acts of this defendant, that there's only one sentence that reflects the evil nature of what he did. So, Your Honor, we're going to ask for a sentence, the maximum allowed by law. We would ask for, on count one, the defendant to be sentenced to a term of life, that be served without parole. I would ask that in count four, cruelty to children in the first degree, the defendant be sentenced to a term of 20 years to serve, and for that to run consecutive to count one. I would ask that count six, the defendant be sentenced to 10 years to serve, and that 10 years be to serve consecutive counts 1 and 4. Count 7, he'd be sentenced to 12 months to serve, he'd be sentenced to that term to run consecutive to counts 1, 4, and 6, and that count 8, the defendant also be sentenced to 12 months to serve, to run consecutive to counts 1, 4, 6, and 7. Judge, that would be a sum total of life in prison without parole, plus 32 years to serve consecutively. I believe that the evidence in this case and the jury's finding that this man intentionally killed his child in the worst way possible necessitates this sentence and only this sentence.
Well, the defendant, Jess Rawson Harris, has been found guilty by a Greene County jury of all counts in this bill of indictment, and that includes malice murder of his 22-month-old son, Cooper Harris, and felony murder of his 22-month-old son, Cooper Harris. He's also been found guilty of the underlying felonies and misdemeanors. It now becomes my duty to determine what punishment will be imposed for these offenses. In arriving at this determination, I am authorized to consider all of the evidence received in court during the trial of the case, except for any evidence that was offered for a limited purpose. I am by law to consider the facts and circumstances of extenuation and mitigation of punishment, if any, as well as evidence in aggravation of punishment. Court should be mindful that mitigating or extenuating facts or circumstances are those that do not constitute a justification or excuse for the offense, but that in fairness and mercy may be considered as extenuating or reducing the degree of moral culpability or blame, except for the fact that the defendant has no prior criminal conviction. There is no mitigating fact or circumstance in this case. The aggravating circumstances are those that increase the guilt or enormity of the offense or adds to its injurious consequence. This court finds particularly that the defendant, Justin Ross Harris, intentionally and unnecessarily, in a wanton manner, caused and inflicted upon the the victim, Cooper Harris, unnecessary and wanton, severe physical and mental pain and agony. The evidence in aggravation in this case is replete by the evidence presented during the 6 weeks of evidence presented to a jury. The jury in this case was diligent and conscientious. They were careful in their observation of the witnesses. They were careful in their note-taking. They were careful when they had the view of the car that was involved. It was not a large SUV. They were careful in observing the seating and positioning of the child safety seat involved in this case. They took careful time in their deliberations. They asked to review evidence that was of concern to them, and it was done so in open court. When they came back into the courtroom to render their verdict, and they were polled by the court and asked if in fact that was their verdict in the jury room, and if it was still their verdict, each stood and each unequivocally said yes, it was. There was no hesitancy, there was no reservation, there was no indirectness in their answers at all. They fairly deliberated and discharged their duties and found the defendant guilty of what factually was a horrific experience for this 22-month-old child who had been placed in the trust of his father, and in violation and dereliction of duty to that child, if not love of that child, callously walked away and left that child in a hot car in June in Georgia in the summer to swelter and die. The state's recommendation is the very least that anyone could deem just under the circumstances of this case, and I will follow the recommendation. Mr. Phillips, if you'll do the paperwork, please. You got it? Okay. If the parties would approach. And the defendant.
You want me to take it back to him, Judge?
No, I want him up here for sentencing, please. Yes, and thank you.
Probably needs to go over that.
Okay. All right, Judge, these have been signed, and as to form, I think it clearly reflects what you said.
Thank you for that, Mr. Kilgore.
Habeas rights to them, though.
I'll do that. The court pronounces the following sentence in the case of the State of Georgia versus Justin Ross Harris, criminal action 14-93124. As to count one, the court imposes the sentence of, as to malice murder, with the jury having found the defendant guilty. Sentence of the court is life to serve in confinement without parole. As to count two, felony murder, guilty. It's vacated by law due to the conviction on count one. As to count three, felony murder, disposition by the jury of guilty. It is also vacated by law due to conviction on count one. As to count four, cruelty to children in the first degree, the jury having found the defendant guilty, the sentence of the court is 20 years to serve in confinement. This will be consecutive to count one, malice murder, life to serve in confinement without parole. Count five, cruelty to children in the second degree, the jury having found the defendant guilty, it will merge into count four as a matter of law. As to count six, criminal attempt to commit a felony, to wit, sexual exploitation of children, with a disposition by the jury of guilty, the court imposes a sentence of 10 years to serve in confinement, consecutive to counts 1 and 4. As to count 7, dissemination of harmful material to minors, with the jury having found the defendant guilty, the court imposes a sentence of 12 months to serve in confinement, consecutive to counts 1, 4, and 6. And as to count 8, dissemination of harmful material to minors, the jury having found the defendant guilty, the court imposes a sentence of 12 months to serve in confinement, consecutive to counts 1, 4, and 6, and 7. Page 3. Mr. Harris, this is to advise you that you have the right to file any action for habeas corpus brought pursuant to Title 9, Chapter 14, Article 2 of the Official Code of Georgia. It must be filed within 1 year from the judgment of conviction on misdemeanors or 4 years from the judgment of conviction on felonies becoming final by the conclusion of direct review or the expiration of the time for seeking such review. That would be the 5th day of December, 2016. You also have a right to appellate review. I know that you've discussed that with counsel because you and I have discussed that previously. So let this serve to remind you that you have 30 days in which to file the first steps toward appellate review. Mr. Kilgore has already advised the court that he either has or will, I would assume will, file a motion for new trial and take the appropriate appellate steps. Is that still your intent, Mr. Kilgore?
Ma'am, I'm gonna take care of it.
I appreciate that. My final observation is this, Mr. Harris. I went back and reviewed and thought about your statement to the police and your statement to your wife when you were taken into custody. And it stood out to me that in both of those, you took the occasion to express your wish that you would be an advocate so that people would never do this again to their children. And I would say, perhaps not in the way that you intended, but you in fact have accomplished that goal. All right. Anything else for the state?
No, Your Honor.
Anything else for the defense? You can take the defendant into custody. Just wait a second, let's get him out. All right. If there is no other business by the state or the defense for the court,
No, Your Honor.
there being none, we stand in recess.
They left us in here for free, so if you need us, we'll be here.